Sorry, but your NIW case is a loser. Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our offices in St. Louis, San Diego, and Washington, D.C. In today's video, we're talking about the national interest waiver. We're talking about employment-based green cards, and we're going to talk about a lot of the calls we've been getting here at the office about the national interest waiver. We want to explain to you sort of our thought process on how employment-based green cards generally go, then explain how the national interest waiver works, and then at the end of the video, we're going to talk about why your case is probably not yet ready for the national interest waiver. Most people who are going to apply for an employment-based green card process need an employer to sponsor them. Most people have to have a U.S. company who is willing to sponsor that foreign worker for a job and for a green card. As you might imagine, there are a lot of rules that go into this process, and you actually have to deal with two separate departments of the federal government. The first department is the Department of Labor. The second department is USCIS. A lot of people don't think about the Department of Labor as having anything to do with immigration, but they do, and the main reason is that they want to protect the American worker. Our federal statutes are designed to protect federal workers, U.S. citizens, and lawful permanent residents who already have status in the United States. And when it comes to weighing the balance of power or the balance of interest between an immigrant and a U.S. citizen or a lawful permanent resident, the U.S. citizen and the lawful permanent resident are always going to win. So the rules are set up to protect American workers, and specifically, they want to protect the wages or the salaries of American workers. That is, they don't want companies bringing in foreign workers, paying them a lot less than what they have to pay American workers, and thereby lowering salaries of American voters or potential voters as LPRs. So a lot of the initial rules when it comes to employment-based green cards are related to that, to the salary. And so that the way the process works is you begin by filing for a prevailing wage determination with the Department of Labor. That is, you have to figure out what is the job category, where is it going to be performed, and what is the salary that's being paid in that occupation in the geographical area. And you do that by submitting that PWD, the prevailing wage determination. Specifically, the Department of Labor is going to determine how much does someone who has that job in that city get paid. And that way they can make sure that the employer has to promise to pay that prevailing wage. And they don't trust the employer to just announce the wage. They use a lot of data, and it takes a lot of time to get a PWD, a prevailing wage determination, so that you can begin the process of employment-based green card sponsorship. So for instance, if Microsoft wanted to hire a software engineer in King County, Washington, they would have to file for a prevailing wage determination from the Department of Labor, and the DOL would then research what are software developers in King County, Seattle, Washington getting paid. And the employer would then have to promise to pay that prevailing wage if they sponsor the person for a green card. As you might imagine, this is a hassle. Employers don't like it. They don't like having to do the paperwork. They don't like having to pay what the government says they have to pay, and they generally don't like the uncertainty and the length of time, which is now 5 or 6 or 7 months to get that prevailing wage determination from the Department of Labor. Then we turn to the next part of the Department of Labor's processing of these, and that is the PERM application. So in order to submit a PERM application with the Department of Labor, the employer has to get that prevailing wage determination and then file the paperwork necessary to publish the job. They have to look at the job, they have to describe the job, they have to do a job posting, and then they have to advertise it. They have to pay for it to be advertised in the newspaper of general circulation in that city, the biggest newspaper. They have to pay those fees, and they have to do a good faith recruitment. They have to receive all the resumes that come in for that job posting. And then they have to sort through it, and they have to be able to articulate why the foreign worker that they want to hire is the most qualified person for the job. Again, they're protecting the American workers. So if a U.S. citizen applies for the same job as the person that you want to hire in the employment-based context, and they have the same or better qualifications, then the employer is prohibited from hiring the foreign worker and would need to hire the U.S. citizen or the lawful permanent resident who has those equal to or greater job qualifications. And you have to do the recruitment in good faith. You can't sort of play tricks with it. And you don't necessarily have to submit all the paperwork related to the recruitment, but you have to be ready for a DOL audit. And a lot of times the Department of Labor will go back and make sure that the process was done correctly, And you always have to be ready and prepared to prove that the foreign worker was the most exceptional person for the job. There have been a lot of downsides to the tight employment market, but one of the things that it does result in is it makes it a little bit easier to show that the employers had a hard time finding U.S. citizens or lawful permanent residents to do the job, and that sometimes helps boost the PERM application and the ability of the employer to demonstrate that there are no qualified American workers, thus the need to hire the foreign worker. Now again, employers don't like that process. They don't like having to publish it in the newspaper. They don't like having to post a job in the office for everyone to see. They don't like having to post that prevailing wage. There's lots of things about this that the employers don't like. But that's stage two. In order for a person from overseas to get an employment-based green card, most employees and most employers are going to have to go through that PERM process. Then once that's approved, which takes another 6 to 9 months, then and only then can you file the petition for alien worker, the I-140, with USCIS, where you demonstrate that this is a job worthy of an employment-based green card, and you have to go through all that hassle with that whole second agency, USCIS. So this leads us to the National Interest Waiver, the NIW. The NIW is a limited rule that allows people who are doing work in the national interests to move beyond the PERM process. They don't have to go through DOL. They don't have to do the prevailing wage. They don't have to do that good faith recruitment. They don't even need an employer. You can self-petition for an I-140 if your work is in the national interest and if the work that you're doing would be advanced by allowing you to not go through the PERM process. So we're going to go through the requirements of the National Interest Waiver, and then we're going to talk about why we think too many people apply for it too early. All right, so there's 3 factors that USCIS considers in whether or not to grant someone a National Interest Waiver. So I'm going to read each of the requirements because I want to get them exactly right. The first is that the person's proposed endeavor has both substantial merit and national importance. That is, that they are advancing the interest of the United States in performing this work or this proposed work. The second is that the person is well positioned to advance the proposed endeavor. In other words, they're the right person for the job. They're the ones who are going to move the country forward by engaging in the work that they propose to do without getting a DOL PERM application approved. And the third requirement is that it would be beneficial to the United States to waive the PERM requirements. So if you can prove those 3 things, then you can get a green card without going through that bureaucratic hassle known as the PERM process that we just described. Now, here's the problem. Too many people apply for the National Interest Waiver too early. Now, I will admit that I am generally conservative on this. I am not going to sell you a bill of goods. I'm not going to overpromise and tell you that I think you're worthy of a National Interest Waiver just because you want to pay me to file a National Interest Waiver application for you. I would rather be much more honest up front, give you our real analysis as to whether or not we think your work is in the national interest and whether waiving the PERM process would advance the interest of the United States, and whether or not you're the right person for the job. We'll talk through all those things with you before we decide to go ahead because we want you to make a good decision. And the problem is there are too many people applying for this when they're not ready. Well, how do we know when someone's ready? Well, I think the best standard is if you just finished your PhD, if you've just gotten into industry, or if you've just getting started, you're probably not worthy of a National Interest Waiver. Now, of course, there are exceptional human beings doing exceptional work right out of the box, and they are doing work that is clearly in the national interest. For instance, when the COVID virus hit, I could see how people could make a strong application for NIW, for National Interest Waiver, when they were trying to stop COVID, and their work in the United States would help advance the interest of the United States and make the country safer. You can see there how someone relatively young might be eligible for a National Interest Waiver, even though they don't have a long history of credentials. But because of the specific work that they're doing, that's the case. Now, too many people try to jump the line and say, I'm doing work in the national interest simply because they can't find an employer to sponsor them. And that's the way USCIS looks at this. They're asking themselves, well, if you're doing such a great job, why can't you find an employer who's willing to sponsor you? So we think that you need to really think it through before you apply for a National Interest Waiver, that in most instances, you should focus your energy more on finding an employer to sponsor you, maybe an institution of higher learning where they're more willing to do this. and less focus on the national interest waiver. The one other way that we really can keep track of whether or not someone is eligible or going to get a national interest waiver is who's going to write letters of recommendation for them. If it's their friends or their buddies from their programs or former professors, that's not going to cut it. You need people who are at the cutting edge of your field to write letters in support of your application. Then and only then do we think you're going to get the national interest waiver. Again, I said that we're conservative on this, but we want you to make a good decision. We want you to be empowered, and we want you to know exactly what you're getting into when you try to get around the PERM application and instead file the national interest waiver. We talk to immigrants all the time about national interest waiver. We talk about the PERM process, and as I mentioned, oftentimes we're pushing them to go back to find an employer. But if you think you have a case and that you are interested in hiring a law firm to help you with your national interest waiver application, or if you've watched this video and you've concluded that your employer is going to need to file a PERM application for you and you want our help, give us a call, 314-961-8200. If you are just looking for information, we have tons of free resources. We have a lot of information on our website, over 1,300 pages on our website. We have 1,500 YouTube videos that we'd love to have you watch, so you can subscribe to our YouTube channel. We also have our Immigrant Home Facebook group where people talk a lot about these kinds of issues. And then finally, we have our Immigration Answers live show, which we do 3 or 4 days a week. You can always call in and follow us on YouTube or in that Facebook group. You'll be alerted whenever we go live, but we try to do it 3 or 4 times a week, and we'll answer any questions you have then for free. So thanks a lot and have a great day.